Hello, ladies and gentlemen, today we are glad to meet you, and we thank you cause you the take time to read our newspaper. There is point that we gonna share with you today. It is about the Supreme Court's about Donald Trump. Have a good day with this news. 1 month away from Super Tuesday, the highlight of the primaries, could Donald Trump be declared ineligible for the United States presidential election? That's the question the Supreme Court will have to answer starting February 8, while the former president announces attempts to disqualify ballots in a memorandum submitted to the country's highest judicial body. This decision could well shake up the process of selecting the Republican candidate for the 2024 presidential election. Here's the explanation. What is Donald Trump accused of? On December 19, the Colorado Supreme Court surprised many by declaring the former White House tenant ineligible for the presidency due to his role in the assault on the Capitol by his supporters on January 6, 2021, in Washington. It invoked Section 3 of the 14th Amendment to the United States Constitution, which prohibits those having taken an oath to support the Constitution from holding federal office if they have engaged in insurrection or rebellion against the country. Thus, this local court was the first in the country to rule that the frontrunner of the Republicans could not appear on the primary ballot in his state. It was then followed by the state of Maine, which made a similar decision on December 28. Passed after the Civil War, this is an amendment that has never been implemented for a president of the United States, explains Sebastian Natrol, an independent journalist specializing in American legal matters. This decision sparked the ire of Donald Trump's spokesman, Stephen Chung, who immediately denounced a deeply undemocratic decision, while announcing that they would appeal to the United States Supreme Court. On January 5, the Supreme Court agreed to rule on the question of the candidate's ineligibility, which will be examined starting February 8 in a public hearing. Could he be disqualified by the Supreme Court's decision? In this election year, the decision regarding the eligibility of the 45th President of the United States will likely be the most important of the cases handled by the Supreme Court. The jurisdiction has two options. It can rule that Donald Trump did indeed participate in an insurrection, thereby making him ineligible for the presidency, or conversely reject the decision made by Colorado and Maine. While legal professionals recognize a third possible option, namely that the decision falls within the exercise of each state's electoral law, it is unlikely to be upheld. It is hard to imagine the court saying that there are different standards from one state to another. Under the 14th Amendment, either Trump is eligible or he is not, and this question will likely be definitively settled, explains Brian Kalt, professor of constitutional law at Michigan State University. However, it could prove difficult for the court to decide in favor of one option or the other, as this legal recourse is as unlikely as it is unexplored. The 14th Amendment is very ambiguous and does not give us any procedure, so we must determine how to declare someone guilty of insurrection, whether a law must be passed by Congress beforehand, and whether this applies to the president, explains Brian Kalt. At the same time, each interpretation of the amendment is subject to differences, especially regarding the definitions of the words oath and insurrection. Can the events of January 6 be likened to those described by the 14th Amendment, enacted following the Civil War? Does the Supreme Court have the ability to rule on political questions when it forbade itself under the political question doctrine? Should it rather let the voters decide given the strong polarization of the United States and the risk of being accused of bias? The Supreme Court has many escape hatches, summarizes Sebastian Natrol. These are also widely exploited by Donald Trump's lawyers, who point out that the text simply mentions an officer of the United States having taken an oath to support the Constitution. Some law professors believe that the qualification of officer of the United States does not apply to the president, who is not explicitly mentioned in the text, reports Sebastian Natrol. Several legal precedents suggest that officers of the United States are appointed, not elected, details the specialized journalist, in their appeal against the Colorado trial. Donald Trump's lawyers also argued that the former president did not swear to support the Constitution. Instead, during his inauguration in January 2017, he swore to preserve, protect, and defend it during his term. These points of contention make it difficult to remove the Republican candidate's name from the ballot. Eligibility for the presidency is usually clear-cut. Someone must be 35 years old, and if they are not, they cannot be president, period. Because of the ambiguity of the question, if the court is not sure of the decision to make, It generally tends to let the voters decide, adds Brian Kalt. Are there similar cases in other states? While states like Louisiana or New Jersey have already rejected lawsuits regarding Donald Trump's eligibility for the upcoming presidential election, official challenges to the Republican candidate's candidacy have been filed in at least 35 states according to the New York Times. The Supreme Courts of Michigan and Minnesota, for their part, have ruled that the former president can appear on the primary ballot in these states. However, decisions made at the local level are subject to approval by the Supreme Court, which has the final say on constitutional law matters. If the Supreme Court overturns Colorado's decision, all other states considering preventing Trump from voting will follow the Supreme Court's ruling and reject attempts to make him ineligible, comments Brian Kalt. The Oregon Supreme Court even chose, on December 12, not to rule on Donald Trump's eligibility until the apex of the judiciary pronounces on the Colorado case. Most states prefer to wait rather than exert all efforts and take the political risk of making a decision that could anyway be overturned by the Supreme Court, says the professor. If the Supreme Court does not rule before Super Tuesday on March 5, where 14 states will hold their primaries simultaneously, Donald Trump's name will be on the ballots. In the event of ineligibility, it will be up to the Republican Party to decide how to reallocate the delegates won by the former president. Thank you for your patience, 'cause you take time to listen our newspaper. Don't forget to subscribe to get more information.